For many months now, we've had our eye on the Peter Moyo Old Mutual saga, and it seems that so far Peter Moyo has been coming out a little ahead in this back and forth. But today, a High Court ruling seems to suggest that the tide might be turning in this entire issue, and it has ruled that Old Mutual actually doesn't have to reinstate Moyo. So, what's happened to change things? What has actually changed, Jeremy? You're trying to get some answers.
You use the right word when you say saga, because it's like a Nordic saga. It's gone on and on, you know, like a five-setter at Wimbledon. Well, joining us, a political and legal analyst, Justin Ramages. Good evening to you and welcome. So, where does this leave Mr. Moyo tonight, then?
So I think it doesn't leave him anywhere. I think it all begins. I think that was just the end of the beginning. So now we go to the appeal courts. I think the saga has a second chapter in it. It seems from reports that he's about to exercise his rights to protect himself and to move in this narrative where he says he was the victimized party. The person who was conflicted was clearly Trevor Manuel, and he wants to rely on those rights.
So he says straight after the ruling that he was disappointed with the High Court ruling. We accept that. Sure. Believes there is a good chance for an appeal to be successful. Would you agree with that sentiment then on the surface of it?
So if we have to break it down into factual circumstances, the facts are, was he conflicted and was he a CEO, and did he occupy mutual directorships at Old Mutual and MET at the same time? Did he receive payments when payments were due and payable in terms of a preference agreement to Old Mutual? So that's clearly... he is conflicted, and I think Old Mutual, from my position, took the correct approach. They wanted they didn't want to wipe out shareholder value. So they said, listen, you've engaged in some strange activities, here's a settlement offer, please walk away. But he's obviously decided to rely on his contractual rights, and he fought it. He won the first leg, he lost the second leg, so now we're up to the third one.
Even a degree of hubris here, wanting to, I would imagine, to protect his reputation.
Sure, and I think let's backpedal a bit. Assuming that he's correct, and he is in the correct position, and he has been unlawfully dismissed, I think he is quite correct in enforcing those rights. However, what we have is two contractual provisions. One that says Old Mutual can terminate with a no-fault clause. So if he's engaged in some commercial malfeasance, they're not happy with it, they terminated without cause, they gave reasons, and in terms of the contractual provisions, you're entitled to do it, despite the court de quo arguing that, no, because there was misconduct, you should have actually relied on this provision. But in terms of a contractual agreement between you and I, you can rely on any provision.
So where does the better weighting lie then? On the one hand, unlawful dismissal.
Sure.
The other side is conflict of interest. Surely if conflict of interest is going to tip the scales.
Sure, and I think we need to look at that. The objective of a CEO, or actually let me correct myself, the objective of a director, whether you're independent or non-independent in terms of South African law, you owe a duty to the company. And in this instance, you are supposed to create the environment, they pay you a lot of money to create shareholder value, which you're obligated to do. In this circumstances, he owned 20% shares in MET, but so did Old Mutual in terms of an ordinary shareholder and a pref share agreement. So in terms of South African law, preferred shareholders get paid first. Ordinary shareholders follow on that depending what the agreement is. In the circumstances, the preferred shareholders, 60 million rand, which is a lot of money, had to be returned to Old Mutual.
This is whichever way this ends, and
sure.
you know, it's just the end of the beginning. There's more to come. On the one hand, it's going to be a millstone around his professional neck for a long time to come.
Sure.
It has also caused a degree of reputational damage as far as Old Mutual is concerned.
Sure.
Why was this allowed to happen in the first place? What went wrong within corporate governance mechanics to enable this debate to get to this point?
Okay, so I like what you're using, corporate governance mechanics. I think it worked pretty well in those instances. He had a particular agreement as a CEO, acknowledging his potential conflict. There was particular governing bodies which were responsible for investigating those. When the dividend was declared, it was red flagged. Okay, the effect of it is they push it up to the chairman in terms of the agreement which they're obligated to do. He deals with it, they execute it. What they said is, here's your notice payment, we'll pay you out for the term, we don't agree with what you did, we lost faith and trust in you, so we don't think you can make our shareholders money anymore under these conditions. So please walk away. But nobody in South African law is prevented from exercising their rights, and he believes he has a case, and that's why I went to court to enforce his rights.
All right. he co-founded this organization called
That's correct.
Capital. I'm correct.
Sure.
Okay. Old Mutual, I think, had an 18 or 20% stake in this particular in this particular venture. Should that allowed to have happened in the first place? Surely, at the get-go, when this formation was being set up, there was already a conflict of interest there.
I'm not sure I 100% agree with that. Let me put it this way. His obligation and his duty is towards Old Mutual, right? Until a share is paid out or until he acts in a position, which he did in the MET according to the judgment, which puts him in conflict, you raise a conflict of interest. Secondly, there's Annexure A and B to his contract, which clearly spells out if a conflict of interest does arise, this is how you manage it. So I don't think, number one, there was a conflict of interest just by concluding a contract. There has to be some engagement in some commercial activity before you do it. Secondly, your interest needs to be upheld against that of the company's interest. That wasn't the case unless this event was triggered.
But this is precedent setting, though. Surely,
Agreed.
You need to change the paradigm in case something like this happens, or not in case, when, you know, subsidiaries are formed again as a result of big organizations.
That is a position, and one that you could take if you want to mitigate risk. And we see maybe it's appropriate because 20% or 17% of shareholder value at Old Mutual was wiped out. So maybe it's a particularly good idea. Also, there's legal fees which they incurred, and now it's an ongoing saga. So maybe it would be better that if you are sitting on a board of a holding company and a subsidiary company, that you shouldn't allow to be on mirror boards. You should be removed. That would mitigate the conflict totally in the form of directorship.
And to use the old cliche, the real winners here, as this goes on and on and on, are the lawyers, I suppose.
I suppose.
All right, Justin Ramages, thank you very much indeed.